Welcome to the award-winning Consumer Finance Monitor podcast, where we explore important new developments in the world of consumer financial services, what they mean for your business, your customers, and the industry. This is a weekly podcast show brought to you by the Consumer Financial Services Group at the Ballard Spahr Law Firm. And I'm your host, Alan Kaplinski, the former practice group leader for 25 years, and now senior counsel of the Consumer Financial Services Group at Ballard Spahr. And I'm very pleased to be moderating today's program. For those of you who want even more information, don't forget about our blog, consumerfinancemonitor.com. Yes, it goes by the same name as our podcast show. We've hosted the blog since 2011 on the very same day that the CFPB became operational. At that time, it was called CFPB Monitor, but we changed it during Trump 1.0 to Consumer Finance Monitor because we expected there would be fewer developments at the CFPB, and that turned out to be the case. We also regularly host webinars on subjects of interest to those in the industry. So to subscribe to our blog or to get on the list for our webinars, please visit us at ballardspahr.com. And if you like our podcast, please let us know about it. You can leave us a review on Apple Podcasts, YouTube, Spotify, or wherever you obtain your podcasts. Also, please let us know if you have any ideas for other topics that we should consider covering or speakers that we should consider as guests on our show. Well, let me describe to you the topic that we're going to cover today. It's a familiar topic, and that is what's happening at the CFPB. And today, we're going to focus on the all-important area of CFPB enforcement and what has happened since President Trump got inaugurated on January 20th, and shortly thereafter, the then director of the CFPB was terminated by President Trump, Rohit Chopra. And then right after that happened, things started to really become very chaotic. And we're going to describe to you during our show today, our guests, there aren't two people I can think of that know this topic better than our two guests that I'm going to introduce in a moment. Because of the length and importance of the topic that we are covering today, we decided to divide the show into two episodes. One that we're releasing today on June the 12th, and part two of this podcast show will be released 1 week from today during the morning of June 19th. But let me set a very general foundation for the discussion that we're going to have today. So there is after people were terminated or after people resigned because they knew they were going to be terminated, at some point in the context of litigation that got brought by the labor union and some other plaintiffs against Russell Vought, who was appointed by President Trump as the acting director of the CFPB. In the context of that litigation, Mark Paoletta, who is now given the title of Chief Legal Officer, he sent a memo dated April 16th called 2025 Supervision and Enforcement Priorities. And in that memo, he rescinded any prior priority documents, and he then focused on what the new priorities would be for supervision and for enforcement. And we're going to get into that more specifically in a very short while. On February 7th, Acting Director Vought ordered all work in the agency to stop. A lot of other things happened, which we'll get into in detail. All enforcement investigations and practically all enforcement litigation was stayed or dismissed with prejudice. Litigation brought by the union representing CFPB employees has temporarily halted plans to virtually eliminate or terminate the entire agency. And this is all, of course, without any congressional approval. On April 24th, after the D.C. Circuit Court of Appeals allowed the CFPB to permit it to engage in a reduction in force, or whether we'll call it from time to time a RIF, if after doing a particularized assessment, they conclude that particular employees were not needed to perform statutorily required functions. RIFs were then announced that would lay off all but about 200 employees in the entire agency, which at that time had roughly 1,750 employees. Enforcement would be left with 50 employees, going from 258 employees. Right now, the RIFs are temporarily on hold as the litigation proceeds, and at some point soon, we'll be getting more direction from Judge Amy Berman Jackson in the D.C. Federal District Court, or the D.C. Circuit Court of Appeals, actually, on what is going to be the next directive with which the people who are now running the CFPB will be required to comply. Well, let me introduce our guests today. And I'm very excited to introduce both of them because I don't think when you talk about going to the horse's mouth, we're going to hear from the horse's mouth today. And I'm going to introduce first Eric Halperin. Eric is currently a senior fellow at the Consumer Federation of America. From 2021 to 2025, which covered the entire term of Rohit Chopra, who was director, he served as the enforcement director at the CFPB. From 2010 to 2014, he served in leadership roles in the Civil Rights Division of the Justice Department, first as Special Counsel for Fair Lending, and later as Acting Deputy Assistant Attorney General, overseeing the division's fair housing, fair lending, and employment enforcement programs. From 1998 to 2004, he was a trial attorney in the Civil Rights Division, and in addition to his government service, he's held leadership roles in the nonprofit sector, including as director of the Center for Responsible Lending's litigation program and its Washington office. So, Eric, very warm welcome to you.
Great. Thank you, Alan. It's wonderful to be here.
And now, let me introduce my other guest, and that is Craig Cowie. Craig is the Blewett Endowed Faculty Chair in Consumer Law and Protection and a professor of law at the Alexander Blewett III School of Law at the University of Montana. He also is the inaugural director of the Blewett Consumer Law and Protection Program at the law school. Prior to joining the faculty in 2018, he practiced for almost 2 decades, including most recently as an Assistant Litigation Deputy in the Office of Enforcement at the CFPB and as a partner in the D.C. office at Jenner and Block. So, Craig, I also wish you a very warm welcome and look forward to you sharing your thoughts today.
Thanks, Alan. Great to be here.
Okay, we're going to talk about priorities. We'll first talk about what were the priorities that the CFPB had during the periods of time when Eric and Craig were there. And then we'll segue into what these so-called new priorities that have been established by Acting Director Vought, what they are all about. Craig, if you could start giving us a short description of the Enforcement Division, and then I'd like Eric to talk about what the priorities used to be not that long ago.
Sure. Thanks, Alan. So every regulator, both state and federal, has essentially some arm that takes care of enforcing laws. In other words, punishing people who violate the law and ensuring that the marketplace is safe for the consumers. At the Bureau, there were a lot of different pieces, some of which had played a role in that, but the primary enforcer of the law was the Office of Enforcement. So they would investigate cases. That's typically not public, right? So they wouldn't, just like the SEC and the FTC typically don't disclose who they're investigating. They would investigate in the background, and then cases, if they thought that there was no there, the investigation would just be dismissed and nothing would happen. That happened in a number of cases I was involved in. We were worried that there was a concern. It turns out when we got a little information from the companies involved, there wasn't a concern and we let the matter go. When, however, the Bureau sees that the law has been violated, consumers have been harmed, then it might elect to take a public enforcement action. And that's where we see either a consent order filed immediately where the other party essentially agrees to be bound by certain terms and the litigation is over. So there's a filing and the case is over right away, or litigation in federal court. Eric, do you want to talk about prioritization? I will say, generally speaking, every regulator has to deal with the allocation of resources and prioritization. In other words, what are they going to choose to do? But from an academic perspective, it's very important that regulators cover the entire gamut of their authorities, because otherwise you're basically telling people that you're not going to enforce in certain areas, and that encourages bad behavior.
Yeah, so before I get into some of the priorities we had under Director Chopra, I want to maybe talk a second about what was the process for how we came up with priorities. And typically there was a prioritization process throughout the Bureau's history. Our colleagues in supervision, it's mandated by statute that they do risk-based supervision and do prioritization in that regard as well. So of course, the director of the Bureau can set priorities and does set priorities for the Bureau writ large. And then the Enforcement Division, our responsibility was to translate those priorities into enforcement priorities. And in the division, we had a series of market specialists who were experts within certain consumer markets. And those individuals would each look in their market and look for the areas where there was the greatest source of consumer harm from illegal conduct. And it was something that the Enforcement Division could do something about. So each of those, they would each produce a market memo for each of their markets. It would be from the staff would have those recommendations, and then the enforcement director working with leadership of the division would translate those recommendations into office-wide priorities. And picking up on Craig's last point, which I think is really important, even though we had priorities, meaning issues that we were trying to focus on and trying to drive our resources to because we thought they were particular sources of consumer harm, we did have one of our priorities was providing general deterrence across the broad number of markets and statutes that the CFPB enforces. CFPB enforces 18 enumerated statutes plus the CFPA across the entire consumer financial marketplace. It's tens and tens of thousands of entities. And so obviously you need to make some choices, but it is important to be active and involved in markets. And you don't want to say you're abandoning entire markets or abandoning entire areas, because as Craig mentioned, that could encourage illegal conduct. So what's important is you can have priorities, but merely because something isn't a priority doesn't mean we didn't bring enforcement actions on it. In fact, we brought quite a few enforcement actions from 2021 to 2025 on areas that would not be considered one of our enforcement priorities. So I think that's a really important point as we discuss what may or may not be the new CFPB leadership's enforcement priorities going forward. So some of the things that were priorities for us in the enforcement division, we had a particular focus on repeat offenders or individuals who had violated pre-CFPB orders in the past. We looked closely at large actors and actors that had dominance in their markets and used that dominance in their market to potentially harm consumers. We also, as as I'm sure everyone, listeners to your podcasts were aware, we were particularly focused also on illegal junk fees, so fees charged to consumers in violation of the law. And we brought quite a number of enforcement actions in that area. Also looked closely at consumer data, furnishing, credit reporting, and other ways that consumer data was used to cut and resulted in harm to consumers. And finally, new market entrants or new product entrants where we saw low compliance with consumer financial protection laws. That is not exclusively fintechs, but it is sometimes prevalent in that sector. And then also there were special populations that we certainly were attuned to in looking at it. One of them was service members and veterans and their families was a priority for us. Other was individuals that were traditionally excluded from the traditional credit markets, be that because they were low income, lived in rural areas, or were subject to discrimination, populations that were subject to discrimination in the past. So those were some of our priorities that we followed. But I also want to emphasize, as Craig said again, because it's really important, we brought cases on non-priority areas all the time, and we viewed it as an essential part of our mission. And an enumerated priority for us was providing broad deterrence across all markets.
While you were there during Director Chopra's term, how many enforcement lawsuits actually got filed? And how would it compare to when Kathy Craniger and Mick Mulvaney were director and acting director respectively, and maybe even Richard Cordray? I mean, there is an impression that there was a ton of enforcement actions that were brought, including right up to the very end. And, but that's just an impression that people had. And you are probably would know what the actual reality is, which I think is considerably different. Am I right?
Under Director Chopra, we filed 87 enforcement actions. I think there's two different, there's ways to look at enforcement output, if you will. There's certainly the number of enforcement actions. It's obviously an important number. And then there's also the size and impact of those individual enforcement actions. So I think it's fair to say, although we brought a number consistent with our commitment to enforce across markets, we brought a number of enforcement actions that maybe were smaller. But under Director Chopra and our enforcement division, we tended to bring larger and more complex enforcement actions. So in terms of the amount of relief that we achieved for consumers during that time, it was something like $6.3 billion in ordered redress, I think around 3.3 or something like that in ordered penalties. So much higher civil money penalties, much higher numbers of redress than were under Craniger. And so I think sometimes you could see a difference in priorities reflects the output of lawsuits. There could be a higher volume of lawsuits against smaller actors, or there can be a slightly smaller number of enforcement actions that tend to focus on larger sources of harm and secured orders for more redress to consumers and more penalties.
Yeah. Does the 87 number include cases that never actually resulted in a lawsuit, but were resolved through a settlement or consent order while the investigation was ongoing?
It includes those. It does not include a number of about an additional 30 lawsuits that were settlements of previously filed lawsuits. So some of those lawsuits were filed under while I was enforcement director, and then we settled them during that time. Many of those were older lawsuits. We continued to litigate a number of lawsuits that were filed under Director Craniger, and a number of those we were able to resolve during my tenure. So that includes enforcement actions, which broadly speaks to lawsuits filed or settlements and through administrative orders filed. And then in addition to that, there's an additional 24 to 30 additional matters that were resolutions of previously filed laws.
Craig, you have something you wanted to add.
Yeah, so it's interesting. Under Mulvaney and Craniger, the numbers were very similar. They filed approximately a little bit over 80 actions over the period. It's a little bit, so I agree totally with what Eric said, which is the numbers themselves are only actually they're an important part, but it's actually a pretty small part of the story because, as he noted, the cases so Mulvaney brought very few cases overall. There was about a several month moratorium on enforcement where they took no actions at the beginning of his tenure. But she brought a lot of cases in her tenure, but they tended to be smaller cases. They tended to be not against smaller entities, against more entities that were more or less judgment proof, so entities that didn't have the funds to pay back consumers for the money they'd stolen from them. Obviously, Director Cordray was around for a much longer period than any of the other directors, and so he brought more cases. But I think it's interesting that, even under Mulvaney and, because he was the first part of the Trump administration, so that's only 3 years, right? Because Director Cordray stayed on. There was all this dispute at the time about whether or not the president had the authority to fire the director of the Bureau prior to the expiration of the 5-year term. And so there was a lot of thought that President Trump would fire Director Cordray, but he didn't. And so he didn't until, almost a year later. So he was the director for about a year of President Trump's first term. So the 80 plus cases that Mulvaney and Kraninger brought were actually only over the course of about a 3-year period, as opposed to the full period, because Kraninger resigned on January 20th, as soon as President Biden took office. So
I think we have a pretty good handle on how you establish priorities and what they were until very recently. So I'm now going to go back to something I mentioned at the beginning of our program, and namely the document dated April 16th, a memo that was written by Acting Director Russell Vought, where he talked about what the new priorities were going to be. And I'm going to, as quickly as I can, run through what's in that memo, so all of our listeners are familiar with it. Then I'm going to, because it's very important to understand the chronology here, after I do that, I'm going to turn it over to Eric, who's going to tell us the context of this memo, which I think is very revealing. But we'll get to that after we actually talk a little bit about what's in the memo. So the memo states that from now on, when it comes to enforcement, and to some extent supervision, because there is an overlap between the two, the focus will be on, quote, actual fraud, unquote, where there are, quote, identifiable victims with material and measurable consumer damages, as opposed to matters where the consumers made, quote, wrong, unquote, choices. And it lists the following priorities. Mortgages was the highest priority they listed. Fair Credit Reporting Act and Reg V data furnishing violations was listed. Fair Debt Collection Practices Act, Reg F, relating to consumer contracts and debts. We're talking there about third-party debt collectors, not creditors collecting their own debts. Then fraudulent overcharges and fees. I guess they're maybe talking about junk fees, but it's not completely clear. And then finally, inadequate controls to protect consumer information, resulting in an actual loss to consumers. There's also a list of areas that will be deprioritized. Loans for justice-involved individuals, that is, people who have been convicted of a crime and maybe sentenced to jail for some period of time. Medical debt, which was a very hot topic during Director Chopra's term. Peer-to-peer lending platforms. Student loans, remittances, international remittances, consumer data, and digital payments. Yeah, they just say they're going to deprioritize it. I don't, what does that really mean? And not bring any cases involving it? I don't know. Another priority will be to focus on redressing what they call tangible harm by getting money directly back to consumers rather than imposing penalties on companies in order to simply fill up the Bureau's Civil Penalty Fund. Another priority, this is similar to what we heard from Eric a short while ago, will be to focus on providing redress to service members and their families and veterans. They will also minimize duplicate enforcement where another federal regulator is currently engaged in or has concluded enforcement. I haven't seen much of that, if any, that I can recall in the past. Then they will not pursue supervision under what they call novel legal theories. They don't define what they mean by that. Although it does not expressly mention enforcement, that was undoubtedly an oversight when they talked about novel legal theories. I'm sure they meant to include that. And then when it regard to fair lending, they clearly are not going to get involved in cases that depend upon showing a disparate impact or disparate effect on a protected class of individuals. The memo states that they will not look at redlining at all, and they will not do a bias assessment based solely on statistical evidence or stray remarks. There, I think they're referring to a case that the Townsend case that they ultimately have undone. They only pursue matters with proven actual intentional racial discrimination and actual identified victims. In those cases, maximum penalties will be sought. That, I think, gives maybe more than you need to know about what's in that document. And now I want to turn it over to Eric, who's going to give you a little bit of a chronology. It's not like they came, the Vought became acting director on day one or very shortly thereafter, issued this document. It was done in the context of very specific litigation, which was interrupting what the goal was, I believe, of the Trump administration. So, Eric, fill us in, because I know you know chapter and verse of how this thing occurred.
Yeah, so I do think it's really important to understand when this document was produced, and maybe that sheds some light on what its purpose was. And I think we can't understand that without looking at the broader context of how it fits into the litigation challenging the attempted dismantling of the CFPB. And I just think in general, we should look at what the administration's priorities are at the CFPB, and by their actions. And I think that's more telling than any words that might be in this priority memo or not. So just taking us back in time, and I know some of your listeners are aware of this because you've covered some of these issues in the past, right? So Director Chopra was fired about a week into the Trump administration. There was a brief period of time for about 1 week where the Secretary of Treasury was the acting director of the Bureau. During that time, there were some restrictions put on Bureau activities, but a lot of activities did move forward. Supervision continued to function. Many aspects of our enforcement work continued to move forward. And then about a week later, for the week of February 9th, he was replaced by Acting Director Vought. And that was when we saw CFPB staff told to stay home and not come into the building. We saw firings that were eventually undone or at least paused, reversed by courts of probationary employees and employees who were serving under a term of years. And then there was a lawsuit filed to prevent the administration from dismantling the Bureau because there was purportedly going to be a RIF of almost all Bureau staff. And what we learned when that lawsuit was filed and Judge Jackson, Amy Berman Jackson, paused that RIF in the documents that were put out in that litigation was that there was a plan to eliminate the entire staff of the Enforcement and Supervision Division, sort of relevant for our discussion today, and an original plan to reduce the Bureau to just a couple dozen employees. And then eventually, in the first large-scale RIF, which the leadership of the Bureau tried to rush out before the hearing occurred, after the lawsuit was filing, it would have taken the staff down to around 200 people. And in that RIF, there wouldn't have been an enforcement or Supervision Division. So that first RIF was paused by the court. The court issued over 100-page ruling, many factual findings, which indicated that at least in the government's first response to the lawsuit, there were a misleading affidavit filed. And again, like what we learned, what came to light in the declarations were filed is that this was not a streamlining. This was an attempted complete dismantling of the Bureau. It was only stopped by the lawsuit that was filed by the union and a number of other plaintiffs. If not for that lawsuit, I don't think the Bureau would still be existing today, even in the form as it exists today. So if we fast forward in the litigation, that injunction, preliminary injunction that was put in by the district court judge was appealed to the DC Circuit. The DC Circuit issued an opinion modifying her injunction, saying that they would allow the leadership of the Bureau to move forward with reductions in force after a particularized assessment. And after that, just days after that ruling, we have the April 16th memo from Mark Paoletta laying out enforcement and supervision priorities. Less than 24 hours or about one day later after that memo came out, we had reductions in force that would reduce the Bureau staff overall by about 90% to around 200 staff. And it would take the enforcement division down allegedly to around 50 people. And what's really key to understanding that, and then as would be predictable, that RIF was challenged in court. And the leadership of the Bureau, in part, relied on the supervision and enforcement priorities as part of their particularized assessment to justify the reduction in force. So I think we have to understand this memo and how it came in that flow of the litigation. And it was after we heard from the DC Circuit that there could be RIF after a particularized assessment, and then immediately before the RIF took place. And then eventually the DC Circuit reinstated the full injunction and paused this RIF. And then that case is now has been argued, and we're awaiting a DC Circuit decision on the original appeal of Judge Jackson's preliminary injunction. So, and one other important piece is if you look at the declarations, and I really do commend people to go look at the employee declarations that were attached to the plaintiff's lawsuit, because they really paint a full picture of what was happening inside the Bureau. So just taking a look at some of the enforcement declarations that were submitted there, it was clear that the RIF would have rendered the enforcement division largely ineffective. There was not care taken to see that we could, presumably if you put out enforcement priorities, you want to be able to execute on those priorities. That is the idea. But then what we see in the actions taken was a RIF that would have made it very difficult for them to execute on those priorities. So just some examples, and there's a ton in there. They RIF'd all, in certain cases, entire case teams on litigation. And one thing I failed to mention was all RIF'd employees were going to lose access to Bureau systems 24 hours later. So no warning was given to the leadership of the enforcement division that was what happened. People had less than 24 hours to transition all their work, including work on complex cases, to employees that would not have been RIF'd. And this is key. At the time the declarations were put in the lawsuit, the leadership of the enforcement division still had not been given a list of who were the non-RIF'd employees. And so how would they even know who to transfer this work to? All the people who were in charge of uploading all the discovery material into the discovery systems were going to be RIF'd. All the economists, forensic investigators, and accountants were going to be RIF'd, except for one economist who was detailed to another agency. There was going to be no staff to respond to whistleblower complaints. And critically, the system that hosted all the discovery data was not going to be able to continue because they had RIF'd the staff who would be able to maintain and continue that contract. So it was clear from the declarations that there was no plan or no care given to an enforcement division that could actually execute on these priorities.
Right. Yeah. So, Craig, at a high level, maybe you could tell the audience your impression of what's really going on.
Yeah, I think Eric's context was very helpful. I do think actions speak louder than words, and we need to see what the Bureau is actually going to do. But looking at what it's done already, it already conflicts with what they're saying. So one part that I think Eric didn't mention was that in addition to dismissing entire, case teams and so forth. The entire litigation, my understanding is the entire litigation support staff, the paralegals, the investigators, the forensic accountants, all got RIF'd. All of them, the entire department. There's sort of none of them left. So a lot of the support people that make enforcement possible weren't going to be there anymore. Some of the cases that were dismissed, I think, there were 38 active cases. My understanding is 22 of them have now been dismissed, including, for example, cases against banks. Although in the priority memo, it says that they're going to shift from non-depository, so non-banks, to banks being the focus. Here we have them dismissing cases against banks. Mortgages is going to be a focus. They're dismissing cases against mortgage lenders. So the cases they're dismissing sort of fly in the face of the sort of stated priorities, making them seem a bit like a sham. I will say also the pattern of the case dismantlement that Eric described in enforcement, that's happening all across the government. So in enforcement departments, in education, civil rights, all throughout, we're seeing evidence of case teams being dismantled and what few remaining lawyers are left getting handed entire caseloads, which, from both an academic, ethical, and former government, former private lawyer, is just like that's a nightmare scenario of dumping complex cases that are moving on people that have no idea what's happening in them, no background in the area, and also who had their own caseloads before this happened and were fully staffed as a matter. So you're taking people who are fully staffed on other cases and you're giving them entire swaths of new cases. And so I think the fact that we're seeing this pattern in places like the Department of Education's Enforcement Office and Civil Rights suggests that this is part of a broader pattern. And I think the other thing that's worth mentioning is that, before Vought came to run the CFPB, he was at the Heritage Foundation, where he was principal author of Project 2025, which very explicitly said that the CFPB should just be dismantled entirely. So I do think it's a very fair question to ask about, are these RIFs and in this memo, is that in good faith? Or is it really just a cover for a chance to simply reduce the Bureau to inefficacy so that it basically can't do anything? The other thing I thought was pretty interesting about this is just that, why 50? They say they would need 50, but they also gave supervision, which is by far the largest person power department at the Bureau historically. It was, a good at least 50% larger than enforcement. And it's also being reduced to 50. It was okay, so 50 apparently is the number that looks like maybe we can make a plausible argument. But I think, and it's hard to know from the outside what's happening, is the way these cuts are happening show that they're not actually thinking about, is there going to be a smaller but fully equipped enforcement division that's prosecuting the administration's, priorities, as opposed to just we're leaving enough people there that we might resist a court challenge. And I'll say that this sort of reduction is unprecedented, right? So directors, when there's a chapter written about this as an academic, right, as we change, it is right that our executive agencies, reconsider their priorities under new administrations. That's how they're supposed to work. But, Mulvaney paused, and I think he paused it for too long, but even he had already brought a case before now when he was in charge. And he also didn't RIF the entire departments, right? We've never seen anything like this. Every administration is entitled to its own priorities and prosecutorial discretion, right? That's the nature of our executive function. But the executive isn't allowed to just simply turn an agency off, an agency that Congress has created and funded, which is what they've done here, I think. And that's what the evidence tends to show, especially when you put what's happening at the CFPB Office of Enforcement in the context of what's happening in enforcement offices all across the government.
Yeah, well, thanks, Craig. So, Eric, I remember when this all started to bubble up, there was actually a case, I think, that was about to be argued in the Fifth Circuit Court of Appeals. And somebody was there representing the CFPB, and he told the court, I'm not prepared to argue today. I just want to stay the argument. I mean, the situation that they put these lawyers into, I think, was just, I would have cringed. The word cringe isn't strong enough. I mean, it's just unbelievable what went on during that time, as they weren't prepared to deal with any of these cases.
Yeah, absolutely. And I think these are dedicated public servants. They are professionals with incredibly high standards, and they were put in incredibly difficult situations, not having to appear in court with I'm sure that lawyer was prepared to argue. He just didn't have the authority to say anything. We had enforcement division attorneys who were forced to show up to discovery hearings and other motions practice in district court and not have the authority to be able to speak because, clearly both unprepared to take over, and there was a certain level of chaos, maybe potentially by choice or a lack, as Craig pointed out. Looking at the actions, this was perhaps the point of it all.
Yeah, just a point of clarification. There's a lot of litigation that was pending and still is pending, challenging regulations issued by the Bureau. And are those cases where the CFPB is a defendant, are they handled by generally the general counsel's office, or does the enforcement division lawyers get involved in that?
Those cases are handled by the general counsel's office. The legal division at the Bureau defends the Bureau when regulations or statutes are challenged.
Yeah, I didn't look to see what the RIF was going to do to that office. Maybe they eliminated it.
The Office of Litigation, which is the office within the litigation the Office of Litigation, which is the office within the legal division that defends the Bureau, was one of the offices that within the legal division that was not as significantly affected by the RIF as some of the other offices.
Huh. That's surprising, because I doubt if we're going to see very many new, if any, regulations issued under Acting Director Vought, or if they ever get around to confirming a new director of the CFPB.
I actually think that does make sense, because although that's true, and it is true that the General Counsel's Office also defends enforcement actions when they're on appeal. So the Office of Enforcement does the trial work, but the General Counsel's Office does the appeal for enforcement actions. But and looking at it, the legal division was cut in half under the RIF proposal, but of the half that remained, a half was in the litigation department, which apparently was slated for 0 RIFs. And I think that's because, although they're not anticipating regulations, what an agency is bound by the Administrative Procedures Act and the law in how it undoes regulations as well as how it passes regulations. So, once the law is in place, an agency can't simply turn it off on a whim or change its position without, reasonable notice and comment and following the rules. So I imagine what they anticipate is a lot of challenges of the deregulatory actions that they are taking. They just, all the guidance memos went away. I don't think there'll be litigation about that. And obviously, if the Congressional Review Act is used to get rid of regulation, that's where Congress disapproves of a regulation passed by the Bureau. If that happens, there's not likely to be litigation about that either. But if the Bureau changes its interpretation of a regulation that's existing, I'm assuming there will be challenges, which we see every cycle change. So I think that's what they're worried about.
We have come to the end of part one of our podcast show dealing with this very important topic of CFPB enforcement under the new Acting Director Russell Vought, the new changes in policy that have been made, and the proposed reduction in force. Make sure that you tune in a week from today on June 19th when we release part two of this podcast show, which will cover a lot of very important issues that we could not include in part one, which we did today. And to make sure that you don't miss any of our future episodes, please subscribe to our show on your favorite podcast platform, Apple Podcasts, YouTube, Spotify, or wherever you get your podcasts. And don't forget to check out our blog, consumerfinancemonitor.com, for daily insights on the consumer finance industry. And if you have any questions or suggestions for our show, please email them to us at podcast, that's singular, at ballardspire.com. Stay tuned each Thursday for a new episode of our show. Thank you very much for listening, and have a good day.